assumption, I'll make the assumption because DSPS is not here today, is that the purpose of the rule is to protect those seeking counseling from harm. There's a lot that I could say on the question of harm. For example, under strict scrutiny, ambiguous proof does not suffice, and certainly there is no consensus among professionals on whether children should be allowed or encouraged to transition socially to a different gender, to take puberty-blocking drugs, or to undergo surgery. There's no consensus on the long-term effects of these interventions. We have some citations in my testimony referring to that. But we can set that issue to the side because even if the state were able to substantiate its claim that harm may occur in some circumstances, the rule is wildly under-inclusive and over-inclusive. In other words, it's not narrowly tailored. For example, the rule does not attempt to ban all viewpoints that cause harm, like depression, in those who hear them, and conversely, it bans viewpoints even in instances where it may not cause harm, such as where an adult patient affirmatively seeks out counseling that accords with his or her particular values, viewpoints, or goals. This lack of tailoring raises serious doubts about whether the government is in fact pursuing the interest it invokes rather than disfavoring a particular speaker or viewpoint. For a law like this, precision of regulation must be the touchstone. If the board wants to prevent a particular harm, the logical approach would be a content-neutral and viewpoint-neutral ban on the harm itself. So for example, WSStat section 948.04 is a criminal statute that bans causing mental harm, as defined. There's a long definition in there, to a child. With respect to that ban, particular viewpoints that could perhaps cause harm are not singled out. The prohibition is on causing the harm itself, regardless of viewpoint. But that's not what the board has done here. Instead, the board is singling out a particular, instead it's imposed a broad prohibition on speech, which may or may not cause the actual harms the board is trying to target in individuals. So what appears to be at work here, in other words, is that the board is singling out particular disfavored viewpoints. The government doesn't have that authority. In fact, once we give the government that authority, it will not be long before other viewpoints are outlawed, whether on politics or climate change or guns or any other matter of public concern. The First Amendment does not allow that. The last thing I'll say on free speech before I move to religious liberty is that this committee doesn't have to take my word for it. Just a few years ago, the United States Court of Appeals for the 11th Circuit struck down a very similarly worded law on free speech grounds, and it reached the same conclusion that I'm advancing here. That's Otto versus Boca Raton. The rule in question also runs afoul of the Wisconsin Constitution's conscience protections. Briefly, Article 1, Section 18 of the state constitution provides in relevant part that the right of every person to worship Almighty God according to the dictates of conscience shall never be infringed, nor shall any control of or interference with the rights of conscience be permitted. The Supreme Court of Wisconsin has repeatedly emphasized that in drafting this religious liberty provision, Wisconsin's framers used the strongest possible language in the protection of this right. The result is a safeguard more prohibitive than the First Amendment of the United States Constitution. Specifically, Wisconsin courts apply, again, strict scrutiny to laws burdening sincere religious beliefs. Many mental health professionals base their speech in whole or in part on sincere religious beliefs relating to sexual orientation and gender identity. To the extent this rule would force these individuals to violate their religious convictions by banning their speech even when it represents their best judgment, it would likewise be struck down under the exceptionally demanding standard that a court would apply. Now, it should be noted that these constitutional problems, like free speech and religious liberty, are not the only problems with the rules, but I am trying to keep my testimony to a reasonable length. The rule also likely violates due process protections by failing to give adequate notice of what speech it actually prohibits, and Senator Strobel was alluding to some of this. The rule does not explain what counts as a behavior or an expression of self related to sexual orientation or gender identity that may not be changed. Does not explain how counselors or patients are supposed to know what the default behavior or expression is. Does not explain whose point of view matters, the boards, the patients, the counselors. Counselors are going to face a nightmare in trying to apply this rule in an infinite number of factual contexts involving concepts on which there is little universal agreement. The result, of course, given that licenses are at stake, will be self-censorship. And for some pushing these types of rules, that's the point. I'd like to end this testimony where I began by repeating that every person seeking counseling on matters relating to sexual orientation and gender identity has inherent dignity and value. Observing that a law regulating that counseling is obviously unconstitutional does not diminish that. Clearly, this is a topic that raises passions on both sides. The case law is clear that the role of our state government in this circumstance is to ensure the free flow of information, not to wade into some of the most profound ontological, moral, and religious debates of our age, the meaning and proper ends of sex, sexual orientation, gender identity, select a winner, and punish those who dare to voice opposing views. If there's any fixed star in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. This famous line, maybe the most famous line in constitutional law, which expresses one of the most basic truths about our constitutional order, applies just as forcefully to speech occurring in a therapist's office as it does in a classroom, a church, or a home. Counselors and their patients should be free to have private conversations about the patient's personal life, struggles, and goals without government interference or censorship. So for these reasons, Wissahickon Code MPSW 20.0225 is not possibly consistent with legislative intent, and the provision's multiple violations of governing constitutional rules is the definition of arbitrary and capricious. I urge the committee to immediately suspend it. Thank you for your time, and I'd be happy to answer any questions.
Thank you, Mr. Lococo. It was well said, and I appreciate you pointing out that, in this conversation, it's important that we treat everyone with compassion and dignity, and that this is a difficult conversation, and it's difficult for a lot of people, and we certainly want to treat everybody with respect and dignity and love and caring and understanding. So thank you for putting that out there.
Sure.
And with that, I'll go to the committee with questions, comments. Senator Royce.
Thank you. Wow, that was an impressive string of cherry-picked cases and conjecture and confidently stated assumptions framed as declarative fact. Isn't it true that prior to Otto, every circuit that has reviewed conversion therapy bans had upheld them as constitutional?
So I'm aware of two cases, one in the Ninth Circuit and one in the 3rd or the 10th, maybe 3 cases, that upheld conversion therapy bans. I think 1 or 2 of them was on the ground that I addressed, which is professional speech. That was addressed by the Supreme Court in 2018. And the other I didn't think worth bringing up in the testimony, but I'm happy to address it in Q&A, which is the argument that, this is the Ninth Circuit, I believe, the argument that this isn't really speech, this is conduct. I don't view that as a particularly persuasive argument. You could say that the conduct I'm engaged in right now is making my vocal cords vibrate. Obviously, counseling is speech. I don't think the Supreme Court of the United States would rule otherwise. But I'll just add, if I may, that on the question of conduct, if this were a law that purely regulated conduct, I don't know that we would be here. There's all this reference to conversion therapy. The bill doesn't, the rule doesn't contain that phrase. Clearly, there's no agreed upon definition. We heard in previous testimony that people are submitting definitions. I don't know what conversion therapy is. I have to look at the language of the rule. I think the phrase conversion therapy is used as a bit of a Trojan horse in this circumstance, because certainly the legislature could ban certain types of conduct. If there were electroshock therapy or some kind of physical abuse or something like that, this rule would prohibit that type of conduct. But then it also goes on and prohibits all kinds of speech. And that's how it's a Trojan horse. It sort of uses stuff that we all disagree with, torture of children, for example. No one in this room supports that. It uses that as sort of a fig leaf to then ban all these viewpoints that are held in good faith by people on both sides.
Well, just referring to a recent Harvard Law Review article, which says the Otto panel incorrectly categorized talk therapy as constitutionally protected speech when Supreme Court precedent, U.S. Supreme Court precedent, would instead suggest treating it as incidental to conduct, which is subject to lower scrutiny. So that's just conflicting with what you asserted. So I think that's really important. Is it your contention that any limit on professional speech is unconstitutional?
Any limit that discriminates on the basis of viewpoint is perhaps automatically unconstitutional, certainly presumptively. Any limit that discriminates based on topic, that regulates particular topics, is presumptively unconstitutional.
So if you are an oncologist and you believe that cancer can be cured not by chemotherapy and surgery and mainstream things, but by prayer, can you still maintain a professional license? And can your professional board not say, hey, you are not treating these patients, you're letting them die of cancer. What you're doing is unconstitutional, we're gonna take away your license?
So what a court would do in that circumstance is it would apply strict scrutiny if the law is regulating a particular viewpoint. In that case, strict scrutiny might be easier to meet if there could be proof that those claims are unfounded.
Right.
In this circumstance, it doesn't matter that all of the professional organizations are united in opposition. That's a reason to protect speech, because speech of minorities is exactly what the First Amendment protects.
Agreed, but why doesn't it matter? How many young people have to go through depression, suicide attempts, completed suicides, for it to matter?
What matters is the proof, and there simply is no agreement that, for example, telling a 12-year-old that it's a bad idea to cut her breasts off because when she's older she may regret it.
Hey.
Because when she's older she may regret
It's
it.
spreading libel. Okay.
But what
That's
about,
enough.
we're not talking about that, we're talking
We
about
will
telling a
remove you.
12-year-old
You won't have the
that
opportunity to
whatever
speak. You
she
can't do this. Okay.
is okay.
Sorry. This is
And that she has worth, and that it's
Yeah,
okay,
he
and that she's
understand.
safe, and that she is gonna be
He's up there, like,
supported and cared
calling
about.
us monsters.
That's what we're talking about.
I'm not sure I understand
Do you
your
understand
question.
what I said? Yeah.
The very assertion that you
I'll
made
be
that
quiet.
a counselor
Thank
was
you.
somehow
I'm
be,
sorry.
making this horrible statement to a child that she should do this, is exactly what is prohibited by this. But, there's this whole right-wing canard that somehow people are trying to convince people to be gay or convince them to be trans, so we can all get toaster ovens. And it is so false and so harmful, and that is the kind of thing that is actually prohibited by this. We're saying you can't try to convince people that there's something other than who they are and who they want to be, and letting them express themselves. So what you just said is an argument for keeping this rule, not suspending it.
What I'm saying is, if a particular viewpoint is prohibited by a rule, there has to be proof, and not ambiguous proof, that it will produce the harms that the law is trying to regulate, and then it has to be narrowly tailored. The MPSW board could have passed a law that was viewpoint neutral and prohibited some of the harms that are targeted. For example, as I mentioned, that law that prohibits causing mental harm to a child. There are child abuse laws on the books. Those are all viewpoint neutral. If you abuse a child, that's unprofessional conduct. If you produce a suicide, that's unprofessional conduct. That doesn't mention the viewpoint, because those effects may occur in some cases, but they're not going to occur in every case. That's my point.
Well, I guess you and I just have a difference on how many young people committing suicide is acceptable to try to protect them from a known harm.
I think we
I guess
agree
if-
on that.